started. Good morning, everybody. Thank you for joining and welcome to the 5th installment of the Climate Change in Environmental Review speaker series. My name is Yasmin Robinson, and I'm the Environmental Review Program Administrator here at the Environmental Quality Board. Also behind the scenes, running the WebEx today is my colleague Marty Benson. So you may see her pop up here and there helping out with the chat. And we also have Denise Wilson, Director of the Environmental Review Program, who will also be here probably mostly during the Q&A. All right, so in support of the Climate Change and Environmental Review pilot program, we've been hosting monthly speaker series events, cohort meetings, and sending out surveys since about February. So if you have missed a session or two, or just want to refresh yourself, you can watch all of those recordings and previous events on the Climate Change and Environmental Review pilot program website. Coming up next month, we are going to hear the industry perspective on considering climate change information in environmental review documents. So I think that will be a really interesting take that we haven't had during this series before. And if you have any suggestions for future topics or speakers, please let us know. You know, we're always looking for more information that's helpful to everybody. And then just a reminder that we are recording today's session. Let's see. All right, so today's speakers bring a really wide variety of experience in thinking about how to create an administrative record. So I'm happy to introduce, in order of appearance, Robert Roche, Assistant Ramsey County Attorney and former Assistant Attorney General for the Minnesota Pollution Control Agency and Environmental Quality Board. Colin O'Donovan, Assistant Attorney General at the Office of Minnesota Attorney General Keith Ellison. And finally, Jean Coleman, Senior Attorney at the Minnesota Pollution Control Agency. So thank you to our speakers today, and I will hand it over to Robert first.
Sure, thank you. And I want to start with a caveat. These are my opinions. I'm here in my capacity significantly more as a former Assistant Attorney General than as a current Assistant Ramsey County Attorney. So these are my opinions, not the opinions of either the Ramsey County Attorney or the Ramsey County Attorney's Office. And I'd like to start with a little bit of background. I joined the Attorney General's office in late 1999, and the early 2000s was a time that environmental agencies referred to as the feedlot wars. And what was going on then is large producers of agricultural livestock, CAFOs as we call them, concentrated animal feeding operations, were building and expanding very rapidly throughout the state. And there was tremendous controversy and tension between the proponents of these facilities and the opponents. And it became very clear early on to me that both the proponents of the facilities and the opponents of these projects did not view the environmental review process as the simple information gathering process that it's theoretically supposed to be under the law. A process where you would gather information to help inform permitting decisions. Instead, both sides of the issue saw the environmental review process as a weapon. Project opponents saw it as a way to attack a project, to stall it, and prevent projects that they didn't want to have in their backyard. And project proponents saw the process, especially if you got to a point where an environmental impact statement was going to be done, as a death knell for their projects. So this led to a lot of litigation. And from my perspective, in the field of environmental law, litigation rarely leads to clarity. I don't believe that the environmental review process is any exception. You know what? I'm sorry. I'm having a little bit of a family emergency. Can we cut to someone else and then cut back to me? I need to go off for just a second.
Sure,
I apologize.
sure.
Okay, I'm going to mute and go off video for.
No problem. Colin, do you want to start yours?
Sure, I'd be happy to. Again, I'd like to make the same disclosure I think you'll probably hear from all of us. My name is Colin O'Donovan. I do work at the Attorney General's office and represent state agencies. I'm here in my personal capacity, and the opinions that are my own. So with that, Robert was going to sort of talk a little bit about the leading up to kind of where we had been, and then sort of I was going to pick up and sort of talk about kind of where are we at, and kind of where are things, where are things going, and especially focusing on the administrative records. And as it relates to the climate change and the greenhouse gases, we have both. Minnesota has both, the statutory goals to reduce greenhouse gas emissions. It was by 30% by 2005 levels by 2025 and 80% by 2050. We also have an executive order 1937. And in that order, it was determined that climate change is an existential threat. Governor Walz also identified that it's a complex problem and that it's disproportionately borne by disadvantaged communities. And I think what those two statements show is two things. One, climate change and greenhouse gases are important to the state, and it's important to our communities, and it's important to our people. And there's also a recognition that where projects are being conducted is important. And I'm going to see if I can share my screen. Are people able to see my screen? I see Robert's back. So, Bob, do you want to? Let me just ask before we go. Bob, do you want to take over?
No, I think that'd be too disjointed. How about if I just go last? You guys, why don't we do Colin and then Gene? Because there's a chance I may get interrupted one more time, and I'll just go last. And I apologize if this has been disjointed, but jumping back and forth would be even more confusing.
And Bob, I need to go last because I kind of sum up after all of you.
Okay, that's fine. Okay, that's fine.
Bob, you're here right now. I mean, if it's disjointed, it's disjointed. I think it'll be because I'm going to be kind of jumping into kind of where things go, and I'll be tying off kind of what you do. I think things work.
Yeah, that's fine.
Let me before you go. I'm going to unshare my screen here, so we're not.
Okay, thanks, Colin. So where I was going with that is, at least back in saying the ultimate, the ultimate grizzled veteran line of back in my day, I don't believe that the environmental review litigation that we went through led to clarity. I think it led to a lack of clarity, especially on the issue of cumulative effects and what constitutes a sufficient administrative record. And on the question of how does a person create a defensible administrative record, I'm going to admit a little bit of bias here. In addition to representing the Minnesota Environmental Quality Board, I represented the Pollution Control Agency. Back in the early 2000s, the PCA made more environmental review decisions and got sued more often than any other statewide agency. And I think they became really, really good at developing very thorough and legally defensible administrative records. So the first piece of advice that I would give to an RGU that is faced with making an environmental review decision would be to contact the Pollution Control Agency and ask for sample of their environmental review records, and then copy that format. If you review those decisions, you see a pattern that emerges as to how the PCA, can everybody hear me?
Yes, you're loud and clear.
Okay, you see a pattern. First there's a good thorough description of the project, a breakdown of the likely effects, a scientific analysis of each of the effects and proposed mitigation. I think it's very important that the evaluation be independent. I always told my client, do not just rely on an evaluation that the project proposer has submitted. And they'd say, we've hired Acme Environmental, and here's their submission. I think courts look at that sort of with a jaundiced eye, saying, of course the project proposer is going to say everything is copacetic, but there's supposed to be an independent analysis. Mitigation factors, it's very important that they be specific and that there has to be a clear factual basis to believe that the proposed mitigation will be effective. I always told my clients one of the best ways to do that is to say, This mitigation measure will be effective because it has a proven track record of success. And here are specific examples where data has shown that, a higher smokestack or scrubbers will mitigate air emissions, that sort of thing. One of my clients really summed it up very, very simply. And I think, this line has stayed with me for a long time. Do your due diligence and show your work. You don't want to just have conclusions. You want to show that work. The other thing I think is very important is you want to make sure that you have responded to every single comment that you receive. And the PCA has a very efficient way of doing that, because a lot of times, the comments will say the same thing over and over again, but just to make sure that you've responded, they'll number the comments, and they might say, comment number 275, please see response to comment number 15. But that way an opponent can't claim that you didn't respond. The findings and conclusions that the PCA generates, I think, are very legally defensible, because they are designed in a way that every single statutory and rule-based criteria that must be considered is laid out, and there are specific findings for each of those. And why that's important is when you're doing an administrative law challenge, one of the bases for reversal is, did you fail to consider all of the factors you're required to? And if you lay out those factors and have findings under each one, it's a good roadmap. As I used to tell my clients, you want to think about your findings almost like a connect the dot drawing. And that drawing draws a picture for a court that shows that you thoroughly considered all of the environmental issues and legal criteria. I'd be interested in, and I don't mean to put you on the spot, Colin, but I'm interested in hearing from Colin whether this still goes on. When I was doing environmental review litigation, these cases went to the district court. I know that the legislature changed that and they now go to the Court of Appeals. But one of the problems that we went through a lot in the early 2000s is there would be motions to supplement the record. So the agency would prepare an administrative record and file it with the court and say, this is all the information that we considered. And then opponents would say, well, here's information that was in the agency's possession that we think they should have considered, but they didn't include it in the record, and therefore you should remand and start the whole process over. There's a straight line from a case called Trout Unlimited versus the Minnesota Department of Agriculture that sort of enabled some of these arguments. I'm guessing that at the Court of Appeals, there's less of that, but that was always kind of a headache, was sort of to determine what the administrative record was. We were able to sort of beat that back. And then
Bob, and I don't know if Colin wants to comment on this, but you asked if that still goes on at the Court of Appeals, and it does. It is much more limited. We tend to get more limited scope in those requests to supplement the record. We tend to agree and supplement the record because the party challenging the decision is aware of those documents, and they are what they are, and we have a final decision. So if it's a draft, at the worst case scenario, if it's a draft decision that was diametrically opposed to where our final decision went, we characterize it as a draft, and we characterize it as not the final decision, and that there were intermediary steps that took place, and we will explain that.
And what we dealt with, and I think this had to do with being venued in district court, is we dealt with some gotcha games by plaintiffs who would sort of selectively hold back documents that would be related to some other project, and then kind of try to throw this zinger at the last minute. And I think they really sort of bastardized Trout Unlimited. In Trout Unlimited, what happened is the Department of Ag kind of got cute and said, we're not considering these documents that were submitted about the project under review because they weren't labeled comments. And the Court of Appeals kind of called foul and said, it doesn't matter if they're labeled comments. If they're in your possession and they're relevant, they're part of the record. And I had some success with the district court saying, you got to read Trout Unlimited in context. It doesn't mean that the agency has to pick up the building and shake it and every single document that someone after the fact will argue is relevant must be included. But I think part of that, and I personally, again, this is my personal opinion, I believe moving those appeals to the Court of Appeals was very, very prudent, because every time we got sued in the district court, it was like reinventing the wheel and trying to explain to the district judge that no, we're not going to have a trial. No, we're not going to have civil discovery. You are sitting as an appellate court, and this is an on the record review. And for some of the judges, that was somewhat almost like the old robot on Lost in Space saying, you know, that does not commute, that does not compute. And they get confused and want to run it like a traditional civil lawsuit. So that I think is a good thing. When it comes to the cumulative effects analysis, which I know is kind of like the point of why we're here, I hate to say it, but at least back when I was doing this litigation, it really depended on the judges reviewing your environmental review decision. I did a memo for the EQB a long time ago when I was their lawyer, trying to get my arms around how are courts handling this issue. So, and the point of the memo was to kind of try to brief the board and the staff to say, if we're going to fix this with rule changes, how do we do it? And what we found is the courts were sort of all over the place on cumulative effects analysis, but there were a couple of guiding points that could be gleaned. One, probably the most important one in my opinion, is be very careful on the question of whether there are related or anticipated future projects. We had a couple of cases where if the record showed any indication that the proposer intended a subsequent expansion, then then those should be considered related and anticipated future projects where the analysis should be included. And the courts would reverse on that. The Minnesota Supreme Court has ruled for project-specific EIS decisions, the universe of projects to be considered is projects that are actually planned or for which a basis of expectation has been laid. Now, a good question would be, what does it mean to say a basis of expectation has been laid? The court didn't provide any guidance on that. And then what is the relevant geographic area? And the PCA, I think, did a good job of sort of defining it for the projects that I was involved in, which would be, there had to be a scientific basis, a watershed, an aquifer, an airshed, if there's a lake or a river near the project, that sort of thing. But you need an appropriate environmental expertise to define the relevant environmental area for the cumulative impacts analysis. And finally, and this is something that the RGUs don't always have a lot of influence over, but I always found it beneficial if you had a specific metric to measure environmental cumulative effects against. Example, an air quality standard, where you can say, with this discharge to this river, the river will still stay comfortably below, the ambient water quality standards, or, with this, this discharge, the air quality standards will be within range. When it's an environmental effect for which there is not a corresponding environmental standard, it becomes more art and less science. Those were kind of my intro comments on the questions of how to develop a record and how to address cumulative impacts. And I appreciate everybody sort of indulging me jumping in and out. And I'll be happy to turn it back to Colin. Thank you very much.
Thank you. Colin, we'll hand it over to you.
All right. Thanks, Bob. I think that thanks for going the way you did, because I think it sort of brings us up to speed to kind of where we're at. And that's a helpful background. As Gene said, there has, the change to the appellate courts has had sort of the focus really being on the record, and when supplementation needs to happen, that's still a possibility, but it certainly happens less. And I think that's it's helpful, and I think it'll be helpful to hear from Jean on her presentation of sort of how to build a good record and how to minimize and prevent some of those, because as you mentioned, sometimes they can be a distraction, and sometimes they're important, but sometimes it can just be somebody trying to use that as a tactic, as opposed to really focusing on the decision, what was analyzed, and how to make the project the best project that it can be. I'm going to see if I can share my content.
Should be at the bottom of your screen.
Yep.
Little share button.
Are you able to see?
Yep, it looks good.
Just the administrative records and climate. Is there anything else showing up, or is that it?
Nope, that's all.
Great. So as I was briefly mentioning, I think what you're going to hear is this is new, but it's also the same. The greenhouse gases and the effects of climate change. We haven't dealt with this specific issue, but we have dealt with issues like this, and this is not something that is necessarily going to change how the process itself works. We were talking about the executive order and statutory, some of the statutory background. So while there may not be certain guidance as it relates to a regulatory framework, there is specific guidance here of some of the things to be kind of looking out for. How do we reduce, and this is the last bullet, how do we reduce greenhouse gas emissions and energy waste? How do we promote economic development and ensure equitable distribution of benefits and address the disparities in impacts related to climate change? And to sort of the 30,000 foot level here, the whole purpose here is that better planning should result in better permitting and better projects that impact all of us. And so, that's really the goal. And so as Bob was mentioning, there can be antagonism back and forth, but I think it's really helpful both for entities that are reviewing projects and for project proposers to have that mindset. I mean, the goal is to get the information, to develop that and use that information as a tool that will then be used in decision making. And so the better information and better planning that there is, the better that we can do these projects and not result in litigation. I think what you're going to hear from here is litigation isn't always helpful. I mean, if you can go through this entire process and if you don't focus on the record, focus from the very beginning in that planning stage of getting it out, it costs everybody. It costs the project proposer who didn't want to, maybe cut a corner or decided not to look at that. The regulatory agencies that are then forced to look at that, or other entities, advocates that comment and say that needs to be reviewed. All of that, the more you do in the front end, the less you have to deal on the back end. And that's really just important. This is just, again, to sort of say, the more, although things are different, we've seen this before. There have been orders and statutes that have required a focus and analysis, whether it's wetlands to invasive species, migratory birds. As you've looked at your EAW worksheets, these are issues that have, over time just been included. So where we're at now with the project pilot, including climate change, again, on the EAW worksheet, this is something that has happened in the past in other areas. And this is shaped not by any one entity. The information and the analysis, as Bob was saying, it's not just the courts or even specific judges. It's governmental agencies that are reviewing it, making their comments, issuing permits. It's industry, and what is the information and the specific data that they are using and they are looking at. That is information that should be incorporated and at least considered. Environmental advocates also advocating for what should be reviewed. So we all play a part in this. And again, the goal is to have the information looked at. This is from one of the earlier presentations, and I think it's really good. I'm going to show two slides from the earlier presentations that I think are just really important from the initial planning perspective. It is a data-focused analysis, and you have to do the inventory. The initial part of the record has to be getting and analyzing and inventorying the right information. Because if you don't, you're starting off on the wrong foot and you're just inviting litigation. And again, that next bullet there, you need to identify where the reductions can occur so that you can, as you're doing, as you're creating that ultimate decision of whether or not you need more, you're looking at that. And this is that second slide that I pulled from one of the earlier presentations. And what I like about this is it's talking about the need to assess the risks and looking at those risks and then incorporating them and explaining how the analysis has been incorporated. Because ultimately, if you haven't done the analysis, if you haven't built that record, you can't do the ultimate, there can't be the ultimate step of how you're going to incorporate that and how you're going to discuss and show that risks have been, managed. And not every risk can be eliminated. Sometimes it can be. And the project, there is a reason that it shouldn't go forward. There's a better alternative. There is something else that can happen. But again, sometimes risks can't be eliminated, and it's explaining and building that record to show, yes, it was considered. This is what the data showed. This is how we considered it. We didn't ignore it, and that's really the key. And so Bob was talking about the wars with the feedlots, and what we're seeing now in pretty rapid time is more case law on the greenhouse gases in the recent years, and on the analysis related to climate change. And I think it goes beyond just which court you're in or who you're before. I think what you're going to see what I'm seeing in the case law is, for example, in a recent case on the Mankato Motorsports Park, it's how the size of the project matters and the type of the project matters. So they were the issue was related to a challenge to a negative declaration on the need for an EIS related to a large motor park that was going to have multiple garages for cars. It was going to have a multiple mile driving track that would have emissions going, restaurants, hotels, golf courses. It was a large project, and I think something that is harder than just what you would think of. How do we analyze that? It's not just something that we've done some housing units, or we've got a feedlot and we have some case law. That is something where it's new, it's coming on in this era of we need to look at climate change and how do we do that. And in that, the court reversed and said that the negative declaration failed to analyze. They failed to address, as Bob was saying, they failed to address comments. It's not enough to just sort of say that's not an issue or point to some generic parts of the record. It's really taking those comments and answering them, or saying there is something that we need to go back and we need to look at that, or we need to amend the EAW. We need to provide more information. And that's where I think that's what in the most recent case, that was from just a couple of weeks ago here on June 6th, is the Pavilion Estates subdivision. And there, in contrast to the large sprawling motorsports park, it's residential units. Something I think is understandable. I think in looking at courts, they understand that is something that is done. That is something that will continue to be built in the area. So I think the size matters, and I think the complexity and general understanding of the projects matter. That's what you're going to see as you're building it. Not only size, but specific sectors. And this is coming from the 2021 Biennial Greenhouse Gas Emissions Reduction Report. And so, whatever project you're in, it's not enough just to look at the location and the geographic range. As Bob was saying, I think before that was really, it's still necessary, but we're seeing with climate and greenhouse gases, specific issues related to specific sectors. And the focus really has to be on what trends are we seeing? Are you in one of the sectors? Is this project going to be in one of the sectors, transportation, electricity generation, agriculture and forestry? Or are we in which are some of the largest there, but which are also seeing reductions? Or are you in some of these others? And I think really that has to be part of the analysis and thinking, what sector is this project in? What are we seeing and what should we be analyzing? And what do we see as those trends? Is the climate changing greenhouse gases going up in there, or are we seeing significant reductions? And if we're seeing significant reductions, does this project incorporate what other projects have been doing to do that? Whether that's LEED certification or other building codes to sort of reduce that, focusing on that, building that record, and saying this is what we're seeing. We're doing something similar, and therefore this should be approved. And that's what you saw with the Pavilion case. They really focused on that they identified how many BTUs would be used. What was the building things that would reduce the emissions, and really built that record. for the court to approve. It may get challenged. It's relatively new. They're still within the challenge period, but that's what they were trying to do, is sort of look and focus on the record and where it's at. In addition to what specific sector you're in, it's looking at the location and identifying appropriate risks. There can't be the head in the sand, or yes, there's riverine flooding, but we're not really going to address that significantly. We focused on tornado protection in an area that doesn't see tornadoes very much. So I think, again, as you're building the record, identifying those issues of what should be analyzed, and that's the hard part. You take the project proposer takes the first crack, as Bob mentioned. Other permitting agencies should also be involved in that, but then also other comments, and taking those into consideration and being able to identify why the record supports whatever decision is being made, whether that's to advance to an EIS or a negative declaration. And so that's in the end. There's been several Enbridge cases, but the one from 2019, the court reversed, and they remanded on the issue. They remanded on an issue of impact related to the oil spill in the watershed, which would be something similar to kind of what Bob was saying on sort of that specific location. But the court there did a nice job of sort of identifying and analyzing, but the EIS adequately analyzed the potential impacts to greenhouse gas emissions. And this is obviously a large project, and the focus was they didn't just look at one stream of emissions. They looked at both upstream emissions, oil extraction, and also some of the downstream emissions to oil consumption. And there the court said that's a sufficient analysis. That's the kind of analysis we need to see going from the top to the bottom, and that's going to be something that can pass muster. Whoever is proposing and analyzing it from a permitting perspective, you need to know and use. I mean, in particular, the proposers, and if it's not a state agency, if it's a local RGU, you need to know and use the appropriate resources. And here, I think if you look on this slide, if your project fits one of these, there's a tool. And if your record doesn't include some analysis related to that, I think it's going to be, you're subject to attack. And so I think you want to understand what tools are out there, what, as Bob was saying, what specific data can be out there. How can we identify what data was looked at and what was specific and how it was being addressed? And so, using the tools that are available. And again, this is coming from the EQB website. It was a previous presentation, but looking at these other tools and saying, are we in the feedlot area? Are we in transportation? Are we doing a bridge build there, and making sure you've at least understood what tools are there. And if you don't want to use the tool, it's identifying why it wouldn't be appropriate for that particular project. I think another common theme, which again passes Prologue, is analyzing alternatives. As you're analyzing alternatives, the analysis, it's going to be helpful to include the climate analysis in not just the project itself, but a robust analysis in the alternatives analysis as well. That's going to be required. And I think the Enbridge case from 2021 sort of is a good, both because there's a majority opinion and a dissent, talks about what are we looking for. And there the commission for the PUC found, and they really focused that there was a truck and rail alternative that was going to be analyzed. And that was found to have the highest greenhouse gas emissions, much higher than compared to replacing the pipeline. And so that was important to the majority. Obviously, the dissent disagreed and sort of focused on, but there were other issues that should have been analyzed and focusing on social costs. And again, that is part of the art versus science. But I think before you can sort of have the art, you have to have the underlying basis. There can be debates as to whether or not it was sufficiently analyzed. But if the alternatives weren't even analyzed as it relates to greenhouse gas emissions at all for some reason, and that's going to be a basis for the project, you're subject to there's going to be some subject to attack. It may be that there's an alternative that just fails for significant other reasons, and that can be the case where it makes sense not to analyze it, but just fair warning that you want to have a good analysis. So to wrap up my section, what we're seeing is sector and location specific climate impacts are important to be considered. Both proponents and government agencies and RGUs need to be familiar with and make use of the relevant resources when they're analyzing both the impacts of the project and the alternatives. And then ultimately building a record that adequately explains the results and conclusions, and making sure that I think Gene's going to be talking about that those resources are included in the administrative record so you can rely on them to defend whatever decision you choose to make.
Great. Thank you so much, Colin. And next up we have Gene, and Gene, I'm going to get your slides up here.
Great, thank you, Yasmin. And I'll start out by, I'm hoping everybody can see that, and it does say Minnesota Pollution Control Agency. So I am actually representing the MPCA here today. So anything that I say is coming from my position there, which is why I won't be talking about anything current or probably not at the specifics that some of you may desire. If you could go to the next slide, Yasmin. My job is to sum up some of the principles that you have heard Bob and Colin talk about. I really appreciate Bob for setting the stage through the history that he related today. I benefit greatly personally from the work that Bob did working with the MPCA and getting us on track for creating efficient, sufficient records and sufficient findings of fact. And I really do appreciate Colin for diving into the climate change context specifically. But what I'm going to do is really give you a list of principles that you can take from today and use as you are developing your record for an environmental review action where you might be the responsible governmental unit. And many of them you've heard throughout Bob and Colin weaving their stories. I heard start from day one, and I thought Bob put it differently. He said, start at the beginning. And if I could sing, I'd start with the Do Re Mi song right now. Some of you can hear that going through your head right now. Start from the very beginning. Start from day one with your eyes on that prize of building your record and building your findings of fact. And that means that you need to do your homework. Well, first of all, you need to understand the rules of the road to get to that goal of your findings of fact and your compilation of the record. What do I mean by understanding the rules of the road? Those are the statutes that are apply through the EQB rules. They are also the rules and authority that apply to you. For example, at the Minnesota Pollution Control Agency, when we're a responsible governmental unit, we have certain responsibilities, authorities, and we don't go out of those authorities. There are people who may want us to talk about public waters and working in public waters. Not our responsibility. It may be an impact in the environmental review, but it is not a permit that we issue. So understand the rules of the road. I think some of these sessions that you've participated in the past or going forward talk about what the EQB rules are, and certainly around climate changes that is evolving in the environmental review world. And you've heard this over and over again, do your homework. What do I mean by do your homework? I mean, your staff needs to review every single page of that application. They need to understand it. They need to look at it with a critical eye. They need to bring in expertise if they don't have the expertise to review the information, to supplement the information. That critical eye, as Bob said, includes, or maybe it was Colin, includes not just trusting the application that is given to you. The MPCA goes through an iterative process with any applicant when there's an environmental review where we're the RGU. And that is because applications are rarely complete when we receive them. And so we identify, first thing we will do is identify where the application is incomplete, and we will ask for more information. Ask questions. That goes with doing your homework and that iterative process with the regulated party and with your experts. Ask lots of questions before you make any decisions. The definition of arbitrary and capricious, which is a standard of review that will come into play if your findings are challenged. A definition of arbitrary and capricious is predetermining the outcome. So don't predetermine where you want to go in regards to the result. You want to get good findings, start from day one with that eye on the prize, but don't predetermine the conclusion. Ask lots of questions, get more information, and rely on your scientists. Due diligence, take a hard look. That goes, those phrases that have been used weave into the do your homework and ask lots of questions. Listen to everybody. And that connects to, listening to everyone connects to those comments. And not just the formal comments that come in during the public notice period, but comments that may come in outside of that period. If it is a document that is in front of you, someone has submitted it before you have made that final decision, and that's a critical time period before you have made the final decision. If you have information in-house, you need to consider it. We get at the Minnesota Pollution Control Agency, when we're the RGU, we get lots of comments outside of the comment period. We put eyes on every single one of those comments. We consider it. We recognize that consideration in our findings of fact, that we received information and it was considered and it influenced our decision in this way, or it did not influence our decision. Those are statements that you will see in our findings of fact. When you're at the point where you're starting to compile your administrative record or your final decision findings of fact, think about storytelling. You know, I started off with singing. Here's another thing to kind of theme to keep in mind. Think about telling your story. What did you do from day one? Here, you understood the rules of the road. Here are the statutes that apply and the criteria that you had to consider. Bob said that's the template that we use at MPCA that he created. We still use it. We tell exactly how we connected the information that we received and our review to those rules of the road. And we then moved into public comments. How did we manage our public comment period? How did we respond to comments? And I agree completely with Bob that your best defense is going to be proof in the record that you have responded in a meaningful way to every comment that you received. Personally, I think we go way overboard at MPCA, but we do it for a good reason. We do it because we want to have a defensible record to show that we did not miss a comment that what may have been critical to our decision. And then provide all of that supporting evidence. Again, starting from day one, create a place where that application goes. Create a place where your public comments goes. And place by place, I mean electronically folder, so you can access that easily when you put your findings together and when you need to provide that supporting evidence. Then it's going to make it easier if you do get a legal challenge to submit your administrative record, which has to be submitted in a fairly short period of time. And I think this final point has been made also, that engage critical reviewers. Maybe they're not, as I said, maybe they're not with your organization. you need to invest with those critical reviewers to review your evidence, to review the story that you tell in your findings, and to review your final findings of fact. So those are the principles that we use. I hope they are useful to you as you go forward down this journey of environmental review.
Great. Thank you so much. I think we do have a little bit of time here for some Q&A. So if everybody would like a little primer on raising your hand in WebEx, if you look at the bottom of your screen, there should be a little hand icon. And if you press that hand one time, your hand will raise. And if you press it a second time, your hand will lower. You can also locate your name on the side panel, and you should be able to raise your hand that way. All right, so do we have any questions for our panelists today? Denise, are you interested in starting us off today?
I do have questions, and I'm excited, and I thank you all for being here. I think that was a lot of really helpful and great information. Just for clarification, when we're talking about an administrative record, we're not talking specifically about only the findings of fact or the record of that decision that you've outlined in your conclusions, but a record is also sort of the information contained in the EAW form. It is those comment letters and other information that may have been considered in coming to your conclusion. I just want to throw it back to the panel and ask, are there other sort of like elements to this administrative record that folks listening in should be cued into, things to, you were talking, Jean, about how to sort of compartmentalizing, but what do you see as all the documents that should be considered in that record, or the administrative record that will go forward should there be a legal challenge?
And I can kick this off, and I suspect that Colin, who assembles the way that the MPCA and the Attorney General's office work together is that the Attorney General's office represents the agency in any litigation. So Denise, as you accurately say, an administrative record only comes into play if there is litigation. I think your findings should be the major component of your administrative record, because as I was suggesting, your findings need to have that supporting evidence. Your findings need to have, for an example, the scientific papers that you may have relied on outside of the application. And if you don't include those in your findings, I don't know why you wouldn't include those in your findings to support that, but they also, for example, would go into an administrative record. So when we work with the Attorney General's office, and when you might be working with your litigation team, if you're not a state agency, once a challenge is filed in the Court of Appeals, there are 30 days for you as an RGU to produce your administrative record. And that's why I say, if you've thought about it ahead of time and you've compiled them and put them into a place separate from all of the other chatter that you might have in your inbox and in your electronic folders, then it's going to make that 30 days much easier. And so in its core, the administrative record for that judicial proceeding is the final decision of the agency and what the agency considered in making that final decision. It's a lot of stuff, but it's not everything. It is not, for example, a meeting invitation that I received on the topic of discussing this. It is not, it may be the application, and it is the application and any supplemental information. It's what was going to say, the scientific studies, it's the comments. Colin, anything else that you can say? It's not all the back and forth discussion that we had, because the court will understand that the final decision came after discussion, and the final decision in your findings of fact is memorialized and articulated in your findings. So the court will not force you to put a damper on that free flow of information and that free flow of discussion. They understand that you kick things around. And so all of that kicking things around is not part of the final decision. The final decision is what we articulate in the end after we have considered everything. And I'll stop there and see who else wants to jump in.
Yeah, Gina, I think you said that's really the focus. What was considered by the, I mean, really that's what was considered. And when you think about what all the things that Jean just said, starting with the application, when we talk about day one, you know, as you're, you know, the state agencies sort of have a process, but for those who don't and who are RGUs, really begin, I mean, as you're beginning, you should have the people who are working on these projects just kind of create a, you know, if they're not really organized, I think you can do a great service to them, just sort of say, look, you know, is there, you know, important things that you're considering? Create a folder, because if you may not need it, but as you get that challenge, if you do get a challenge, that's the information. You're not. There's a specific timeline, and it's short, and you want to be able to get to that. So as the application comes in, start your folder. That folder. If you have a shared drive, you can start dropping information in there, and then at that point, you can, as Jean said, you can decide what was actually considered as, you know, and some people do more than others, you know, sort of, you can begin to look at that and say, what do we consider? And that's, as Jean was saying, I really do think you look at those, you know, you look at those findings to say, you know, how did we get to this considered and reasonable decision that we want to defend? And one of the things that from our office that I do, because we're often, you know, these projects sometimes go on for years and then we get called in later, is that's the first place I go to as well. I look at those findings and I say, and MPCA does a really good job finding one. All right, what is this saying, and what support what would I be looking for in the record that would support that? You know, I mean, because if I see a glaring hole of, you say X, for example, that you did consider some greenhouse gas, and then I look and say, did you guys use the tool? Yes, we did. And you mentioned a specific tool, and then I go into the record and I say, where's that tool? And it's not there. That's sort of the iterative process that we always engage in. And it's not, I mean, you know, obviously full disclosure, nothing's ever perfect. I mean, as I mentioned earlier, the goal is really, if you take a good cooperative perspective, it is to get, you know, the good planning, good permitting, and a good project. And so it's, you know, if something's not in there, and you know, looking at that and making sure that you're doing your best that you can, and then there's an ability to supplement. I mean, if you miss, I mean, surprise, surprise, sometimes there are inadvertent, you know, misses, and there's rules, one for, you know, to incorporate that and to include it. That's great, and so that's what, from my perspective, is really important. And I think I would say the one note that Jean's already hit on is, oftentimes the RGUs, you know, have scientists on staff, and they are people, but they are so technical and they are relying on studies sometimes without even knowing that they're relying on a specific study. They know this information so well. And I get this all the time with the state agencies that we work with. And sometimes my job is to sort of say, great, we got this, we have a finding that makes sense to me. I'm not a technical expert, but it makes sense. What, you know, I can't put your brain on the paper. What were you thinking? Oh yeah, you know, there's a specific study that is right on point. And it's sort of let's get that in there.
If I can just add to that, and it may have been you, it was certainly from the AG's office, asking the Minnesota Pollution Control Agency, how do you know that? And our scientists would say, because I learned it in school, we have entered textbooks into the record because it's a standard methodology for calculating something. So sometimes your record goes down that deep.
So thank you, guys. I'm going to switch over quickly because I see someone has their hand raised. And I want to give members of the audience a chance to ask that question too. So
Yeah, it looks like Sita, your hand is raised and
Hi.
you are unmuted.
Okay. Can you hear me okay?
Yes.
Hi. I know Colin briefly touched on the fact that different communities experience disparate impacts from different projects. And I know that MPCA has an environmental justice policy. How do you recommend that other RGUs go about including environmental justice in their decision making so that it doesn't get challenged in the Court of Appeals later?
It's a good question. It's pretty broad, and so I do want to be careful on sort of providing advice. I don't in my role I can't provide advice to on any specific issue to somebody who's not my client. But you know, in this context, I think what we're really talking about is going back to what we were saying in the presentations of, did you identify those did you identify in the beginning those communities? Because that's something that everybody, the project proposer should be looking at, and not ignoring that the agencies should be looking at and making sure that they were, if there is a community that's going to be impacted or not, sort of identifying that, and again putting in the consideration. We identify that this was present or within the geographic area that could be, but ultimately our decision was that it would be or it wouldn't be. And I think it's just going back to, have you done the initial inventory, and are you dealing with the right, have you sort of identified those issues? And if so, then I think it's really just digging in and saying, okay, inventory's done, we have no such communities, our project isn't going to affect that, and then you don't have an issue. Or conversely, it is going to be impacted. How is it going to be impacted, and how have we addressed that? Maybe it's we decide not to do that project. Maybe it's we look at an alternative or all the other alternatives, and there's no better alternative, and it's sort of addressing maybe through mitigation. So there's a lot of ways. I mean, I know it's a broad question, but I do want to, it's going back to sort of those basic first principles of, have you identified it, have you considered it, and then justifying your decision, whatever that happens to be, of, and here's why we came out the way we came out, and that's reasonable, and it's supported by substantial evidence, and it's not arbitrary.
Thanks, Colin. It looks like we are running up to our time today, and I think this is a topic and a panel that could go on and on forever, but it will go on in the cohort meeting. So if you are in the cohort group, you can log off of this and check your calendar invite for another link. Thank you everybody for joining today. Stay tuned for our communications push for next month's event. And I'm excited to see you next month. All right, thank you.
Thanks again for setting it up.
Thank you. Bye.